Hey, everybody, I get this question quite often. How do I avoid my heirs from getting at war with each other after we're gone? There's a lot of things you can do, but I work with estate planning attorneys quite often, compiled kind of a list of what they're really recommending on that side, but then applying some of that good, well-rounded logic to it. All right. So here's the thing. A properly designed documents, whether it's a will or a trust, is certainly going to be helpful if it really does come to a court case. When the will or the trust is designed properly, the legal challenges are pretty clear and clean cut. They don't really have to drag out, and they don't have to have problems. So certainly attorneys are going to want the right documents. Appoint an impartial or institutional and or professional executor. Look, the logic here is if cousin Sally is at the center of this and everybody's screaming at her, it's going to get really painful. But if there's a professional third party that has no relation to anybody else, they're going to say no, no, yes, no, yes, no. And that's it. They're not going to emotionally get involved. They're going to get this done and move on. That's what they're going to do. And so if we do have a case where there's likely some issues out there, then maybe hiring somebody to settle the estate is a better idea. Okay. Make your intentions clear and explain them especially for any unusual circumstances. Okay. You can do this in a meeting. You can do the only reason, look, a meeting is good, but you should also do it in writing is what I'm getting at. Okay. Put a layman's term letter together. You don't need an attorney to draw this up. It's just a letter that explains your wishes. If your daughter gets 55% and your son gets 45%, I sure hope that there's a valid reason for it. And by explaining it, that will help avoid those conflicts and problems. Okay. Here's the thing. If you're going to make changes to documents, if you're going to create a will or a trust, and somebody could claim that you're not mentally astute enough to do that, then you need to take measures to cover your rear end. That's a problem as I see it. My mother-in-law has Alzheimer's. When we had 2 documented letters from doctors stating she has Alzheimer's, we gave her her trust and she changed it every single day. We had a copy of the real trust. She changed it every day. She disinherited somebody. She reinherited somebody. She pulled it from this person. She gave it to another person. It changed every day she woke up. It was a terrible thing, but we saw it. It was happening constantly, constantly, constantly. So get doctor's letters that say you're of sound mind. Get witnesses. If the whole family is involved and everybody that is going to benefit from this, then they should all sign it and state, as a witness, we understand that this was her wishes. So take measures to make sure that people know you were of sound mind and or that all of the responsible parties are agreeing and understanding your wishes. And then there's that no contest provision. There is wording you can put into a will or trust that basically says if somebody contests this will or trust, they're getting nothing. Now, understand that this somewhat promotes resentment. We have to be careful about this wording, but in some people's families' cases, that strong wording is needed. So that is possible in there as well, but you're really going to want an attorney to draw up documents like that. Then there's the most common reasons that they're going to contest the will. You've got to understand these because it helps you avoid them, right? Undue influence. Undue influence is one of the main reasons people will contest a will or a trust, meaning another child created a situation that got them more. For instance, I'm putting you in a home unless you give me 70% of everything. Stuff like that. You got elder abuse on that gray area there. There's elder abuse. There's people imposing their influence on somebody to get something out of them. That's something you have to be very careful of. If there's an imbalance in what you're giving your heirs, we have to be careful of anybody thinking there's that undue influence. Incompetence. If you're creating documents or changing documents and you didn't prove it, That's one of the main reasons people will go out there and contest your wishes. They will show that you weren't competent when you made these changes. Fraud. Okay. Unfortunately, I've seen it, especially with power of attorneys. Holy cow, I've seen tons of fraud. And that's why it's so hard to use power of attorneys. But understand that there is fraud and criminal activity out there when it comes to creating these documents. Fraudulent trusts, fraudulent wills. Somebody else created these and swapped them out with yours type stuff. And then ambiguous language. Okay. Just not clear. Leaving a gray area. Not knowing who gets what, or wording it in a way where it could mean that this, but it might mean this. And that's the job of a good lawyer, is to create documents that are very clear. And that becomes very important as well. So this is where the logic comes in. While you're alive, there's a lot of things you can do. Evenly split things. If you got 2 kids, 50-50, right? If you've been gifting and helping one of the kids along the way, while you're alive, that's great. Then gift and freely give to the other child, whether they need it or not, to keep it fair, right? The gifting while you're alive becomes very dangerous, especially if it contradicts the trust. If everything goes 50-50, but you've been handing your son money every month trying to help him out, the other kid has a complaint. And whether it's right or not, it's valid, right? You got to understand that. Don't appoint an executor that can't do the job. And this is honestly very common. And this is where problems begin to occur. Okay. In my family, it's pretty obvious. I'm going to be the executor of the trust. I know what I'm doing. I can get things cleaned up and taken care of very quickly. And my sister is not going to contest anything because everything's 50-50. And my parents have been wide open and honest about it. Okay. One of us needs the money more than the other, maybe, but that doesn't matter. And that's the hard part. It's in the will of being fair. Now, if maybe your scenario is different and you have one child that is really rich and doesn't need any of your money, as long as you're open and honest about it, then give it all to the one that does need the money if you want to, as long as the one that doesn't need the money is not going to get hurt by that. Okay. But you got to go through and you got to explain it, and you got to make sure that you appoint somebody that has the ability to do it. They don't need to know everything about finance. They just need to be able to get a project thrown in their hands and actually get it done. And that's where I see the problems, because these estates that take years to settle and get cleaned up is because it's somebody that has no idea what they're doing, or there were assets in there that were illiquid and impossible to distribute. Those are the only 2 reasons. Every investment account can just get liquidated and moved on. There's very few investments unless you're into private investments. So we've got to make it easier, and the heirs have to be able to do this. And if you have heirs that don't know what they're doing, a good advisor can usually jump in and get this cleaned up very quickly. Give the executor all the checklists they need to get things done. Hey, now go do this. Hey, now go do this. Hey, now go do this. A good advisor is going to do that. I certainly end up seeing it a handful of times each year and making sure that we're getting things cleaned up and settled. Most advisors are going to want to be hands-on because they certainly want to keep the money in-house and they want to manage it for your kids. It's selfish, right? So a good advisor is going to want to help out. Be careful about the uneven gifting. Again, I already brought that up, but while you're alive, giving one kid a bunch of money and not the other, and then giving it 50-50, that's a reason for an argument, okay? Have a list of accounts and assets. Make this easy for them. If they have to go through a scavenger hunt, that's what draws this out. They don't know where your money is. And if you have 27 accounts in 27 different places, it's not easy to figure out. So with your will, with your trust, make sure that you have a list of where all your money is, where all your accounts are, any insurance policies, anything. List it all out for them. Leave a personal letter explaining your wishes in layman's terms. Brought this up earlier. Even lawyers agree that this is a good way to do this. just in layman's terms, explain any weird things that you're doing. Tell your heirs you love them and that you're splitting it up this way, and you're near and dear to your heart is this charity, and you wanted to make sure they got a little bit too. Whatever the case may be, put it out in your own words. Okay, the heirs love hearing from you after you're gone. Have the family meeting and convey your wishes. It's always, again, to avoid these arguments, avoid these wars, make sure everybody's on the same page. All right? Avoid late life changes. Again, are you of sound mind? It's a gray area. It doesn't just happen overnight. There's no switch, right? So don't give them a reason to think that you were making these changes over and over again. This happens. It's very normal. We see lots of clients ask and want to do this. Count beneficiaries are the most important. Okay? And that's why I see it happen all the time. Clients come in, I want to change my beneficiaries. I want to change my beneficiaries. I want to change my, and sometimes it's, I want to change this one to 15% and this one to 10%. This is not something that you should do because it gives them reasons to contest this. Because it is, especially if you do it over and over again, it is a track record of somebody that is not of sound mind. Okay, so set it and forget it. Somebody dies, that's a reason. You got somebody on your beneficiary list that's no longer alive, you want to go change them, perfectly fine with that. But other than that, be careful about your ebbs and flows of your feelings on people and changing how much they get. Okay. A good advisor should be there to help to distribute the estate. Look, we do the best we can. I've seen so many different scenarios. I had a husband and wife. The husband flat out said he's hiding stuff from both of us. They had a trust. Wife ended up in probate when husband passed away, even with a trust, because he hid over $100,000 worth of treasuries in the back of the desk that were only in his name, had no beneficiaries, and the treasury wouldn't release them. So she had to go spend a couple $1,000s in probate just to get that money out from the treasury. So understand that hiding stuff and all that, it's not good. But this now recently widowed woman was expected to unravel this mess when she didn't really know what she was doing. And that wasn't fair. And if I wasn't around, or any good advisor wasn't around to help her navigate this, $100,000 would still be sitting around at the treasury right now. Okay. So make sure that if your heirs are going to need help, trust me. An advisor, like a financial advisor like myself or any other good financial advisor out there, they are way cheaper than hiring a lawyer to settle estate. And when you have a trust, there's a reason that lawyer's business card is right in front. They want you to call them. That's reason that they wrote it out in lawyer terms, so that everybody that reads it goes, huh? What? I don't understand this big book. And they get overwhelmed and they want to go pay somebody else to do it. Well, a good financial advisor, they're not going to charge fees for this. They're just going to be there to help out. And again, it's in the hopes of keeping the money under management and helping the children make right decisions, right? Instead of go buy a Corvette with it. All right. So hopefully that helps. It's just something to keep in mind when we're considering how to leave things for our heirs. If we can help in any way, give us a call, shoot us an email, comment below. Always love the comments and questions. In this part of the series, I rely on your guys' questions. Any questions I see in there, I put a video together on it. Thanks again. Like our page, subscribe to our page, share it with your friends, and we'll see you next week.